Well, it's what I have referred to as the fairness requirement. I think that sort of more captures what's going on. That is that you have to devote all of your disposable monthly income to plan payments unless you have a 100% plan. If you have a 100% plan, then if you've got money left over after making the plan payments, that's yours to do with as you see fit, of course, within the confines of the law. So that is the gist of it, and we did talk about that a little bit in the answer to the first question. Sometimes people will somewhat colloquially use that term also to refer to what I refer to as the Chapter 7 liquidation requirement for Chapter 13. It's also sometimes referred to as the best interests of creditors requirement. So in order to understand that requirement, we need to take a step back to Chapter 7. Now, I know we're talking about Chapter 13, but there is a principle in Chapter 7 that's very useful in understanding this particular concept. In a Chapter 7, typically the creditors get nothing. And so you emerge from bankruptcy having had all your debts discharged, or at least all the dischargeable debts discharged, without your creditors getting a dime. That being the case, well, from the creditor's perspective, that's a bit of a hit. There are some limitations. One limitation is on what you get to keep. You get to keep some stuff, but there's at least the potential to lose possessions in a Chapter 7. So one of the things we include in a set of Chapter 7 bankruptcy papers is a complete listing of everything you own, even down to the clothes on your body. And all of your possessions get divided into two categories: exempt and non-exempt. The exempt stuff, that's yours to keep. The non-exempt stuff is fair game for the Chapter 7 trustee in a Chapter 7 to seize, liquidate, and have money to pay your creditors. And we determine whether an asset is exempt or non-exempt in California by appealing to one of two exemption tables. We don't use the exemption table that's in the bankruptcy code. We have two state tables. One table is for homeowners with equity in their principal residence. The other is for everybody else, what I refer to colloquially again as the renter's table. Each category has a list of, each table has a list of various categories of possessions. As we list your stuff, we stick it into these categories with the hope that it fits all the way into the category and is protected from the depredations of the Chapter 7 trustee. Anything we can't exempt is non-exempt and goes into determining how much creditors get paid through that Chapter 7. In a Chapter 13, which is really what we're talking about now, you get to keep all your possessions. No trustee is going to seize assets and liquidate them. But we still go through the exercise of listing all your stuff, dividing it into exempt and non-exempt categories. Because one of the requirements of the Chapter 13 plan is, over its lifetime, which is typically 5 years, although it can, under certain circumstances, be less, you have to pay back your general unsecured creditors at least as much as they would have gotten had you done a Chapter 7. And when I say that to people, they're usually confused. Wait a minute, I thought in the Chapter 7 they got nothing. Well, remember, if you have non-exempt assets, then the Chapter 7 trustee would seize and sell those non-exempt assets and have money to distribute to your creditors. So we still determine the value of your non-exempt assets because that is the minimum that you can repay your general unsecured creditors over the life of the plan up to 100%. They never get more than 100% of what you owe without interest accumulation. So that's what's known as the best interest of creditors requirement, although sometimes people will imprecisely refer to that as the best efforts. But really the best efforts is you are required either to devote all of your disposable monthly income to the plan or you have a 100% plan.